Fighter fikile kweli shumi fighter titifu magamnande ama fighter fikile kweli shumi fighter titifu magamnande ama fighter fikile kweli shumi fighter titifu magamnande ama fighter fikile kweli shumi fighter titifu magamnande
Fighters, let's go down. Come this side. Please create way for others. Fitting, Gamo, let's go. Bulelamba bangwa fitting. Let's go, fighters. Please open there. Don't stand on the road. Please move there. Move. So that others can move as well. Let's go.
Fighter fikile kweli shumi fighter titifu magamnande ama fighter fikile kweli shumi fighter titifu magamnande ama fighter fikile kweli shumi fighter titifu magamnande ama fighter fikile kweli shumi fighter titifu magamnande
Fighters, please create space. Let the other fighters pass, please. Fighters, on the screen, we are showing the case. We are going to try and get the volume so that you get to hear what is being said inside. So, let's try and be orderly. Fighters, Baba are shifting go fast. There is water down there. There is enough water. If you want water, the bathrooms are down there. Everything. So let's move. There is nothing that is going to happen here. Thank you.
vote for yea or nay represents, or it's a mandate that is carried from the electorates. So in other words, you invite us as the court to look at the issues de novo and say, you may have voted the way you did. We don't think you voted correctly. We think this is the correct way to vote. Or go and vote again. I don't think we can do that. I don't think we're competent to do that. This is the will of the people. The people at that time were the ANC, which had the majority vote. I'm not sure we can do that. And I'm also not sure whether there is any evidence except the pronouncement made by Chairman Mantashe when he says, ask or check what Makosi costs.
Yes.
But that's
Justice Matopo, may I just start with the second argument, the second proposition first, which was about democratic will, and that the court must have some restraint in engaging that where there's an expression of democratic will. You remember that argument was tested in the SCA in the Delay matter, which was one of the first matters where parliamentary proceedings were subject to constitutional control. And one of the arguments that was raised by and I speak subject to correction, but by Ms. Delay, was that if she was subjected to disciplinary measures inside the House, that which would have the consequence of her being excluded from participating and sitting as an MP, that would have a political consequence for her voters, because it means they would effectively be unrepresented. And that's the other side to the coin of the way in which you've constructed democratic will for me. And that argument was rejected in terms because the SCA said that even though that consequence may be whatever that consequence is, i.e. that an MP elected by certain voters might not be sitting in the House, that does not change or derogate from the court's obligation to make sure that when Parliament engages whatever it does, be it a disciplinary measure or an internal procedure, that it does so for lawful reasons. So we would say that the response to the political will argument is the lawfulness of the reasons relied upon to take that particular decision. And if unlawfulness can be founded, then that's sufficient for the court to intervene and invalidate.
But let's not lose sight of the fact that the vote was underpinned by a report which the majority of the members of the National Assembly thought it was fundamentally flawed.
Yes.
They exercised a proper discretion, according to them, to say, we are not being dictated.
No more skipping your daily SPF. Use Hydro Boost SPF. $50 for all-day hydration and protection.
The individual ANC MP says, and I'm not hooking the entire submission on this, I'm just saying here's another indication of the reality of how politics operates in the House, is Ms. T. Mohammed Phala. Yes, Mohammed
Phala. Correction of her votes, whether it should be yes or no.
So that's it. But even if we didn't have that evidence on the record, the debate goes back to that earlier Glenister point that I made, which is that it's not wrong for a litigant to say that the structure adopted in decision-making lends itself towards unlawfulness, and that the basis of the attack which is being launched, and which my clients have launched, is to remedy that potential unlawfulness which stems from the structure as it exists. And so we would say, never mind the evidence, there's also the Glenister line of arguments which allows us...
Before we leave this point, doesn't that interchange or reference to Mrs. Mohammed Phala indicates that she looked and realized that her vote was wrongly captured? She wanted a correction of that, and that in itself would mean that she exercised her mind. Or we should read into it that she has been influenced.
But look at her actual words, because that's important then. Because what the actual words say is, it says, "It came to my attention that my vote for party line is captured incorrectly. Vote for party line is no." And then she goes on to say, "It came to my attention, interjections, that it was recorded as a yes. I vote no, thank you." So what she herself tells you is that of her mind, it's that she was responding to her party line. And remember, there's a distinction here about the party line. I think, based on UDM at least, if it was a nakedly political party line, so in other words, Minister Lamola said, whatever this report says, as an ANC MP, you vote against it, come hell or high water. That would be a clear violation of UDM. But in this particular context, there's a clash here between the party line, which is constructed on what we say is an incorrect evidential threshold, which is then dictated to party MPs to vote it in a particular way. And when her vote is accidentally recorded as going one way, she stands up and she says, "I'm sorry, my vote according to the party line should go the other way." And that takes us back to the UDM territory of the clash between political direction and constitutional obligation in terms of the oath of office. And we say that that's the territory we are in.
But we all live in South Africa. And we know how...
Last time I checked, yes.
What's wrong with South Africa?
Yes.
What's wrong with voting according to party lines?
No, but
all the time.
May I suggest this? That
all political according to party lines.
That's perfectly correct. But what UDM foreshadows is the clash between those party lines and constitutional obligation. But if we step away from that UDM clash point, and let me accept for the moment what you say, that party lines are perfectly legitimate, then what that invites is the party line given and relied upon, and whether that line is a lawful reason. And that takes you to the first example I sketched out.
It's something else.
Yeah, so I think, yes, that's what I would say.
All right, let me conclude.
Sorry, there was a second response I owed you, I think. The first one was about the will of the people. Judge, I'm in your hands.
Let me conclude.
Okay.
The difficulty that I have which has been shared with you by all my colleagues. It's the hurdle that you have, for lack of better word, carefully sidestepped, the one relating to the delay. You haven't told us why. You had an opportunity. My sister Tyrone took you through your affidavits, your replying affidavit, when there was an opportunity to do that, and you elected, wisely or unwisely, not to frontally deal with the question of delay on the basis that you're seeking a declaratory order. You can bring it any time, you're not hit by the review. I don't think you're right. And I don't think that argument is sustainable. And if I'm correct, will it be appropriate for this court to dismiss the application purely on that basis alone?
No.
But why should we deal with other issues? You've got a delay of about 14 months which is unexplained.
Well, may I give two references? Both are judgments of this court. The first one is Khumalo, which Justice Matopo will be familiar with. And at paragraph 52, in response to this particular argument, this is the response to be made. It says, the majority in Puerta held that delay cannot be evaluated in a vacuum, but must be assessed with reference to its potential prejudice to the affected parties and having regard to possible consequences of setting aside the impugned decision. And then, that's paragraph 52 of Khumalo. And then in Tassima, at paragraph 163, where that court in Tassima referenced Khumalo, at paragraph 163, the court said, this court emphasized that an important consideration in assessing whether a delay should be overlooked is the nature of the decision. This was said to require analyzing the impugned decision within the legal challenge made against it and considering the merits of that decision. So insofar as delay is an obstacle that stands in my way, so to speak, I am willing to accept that delay may be relevant for the purposes of the remedy that the court ultimately grants. But it is not an ouster to the court to consider the merits, because that is the question of right which is linked to 1721A. And that's the rights issue, the merits of the challenge. Ultimately, you might conclude that the merits of the challenge are good, but because of the delay under 1721B, you're not giving me any effective relief. That would be competent for you to do, but delay on its own with respect is not an ouster to the court's ability to adjudicate the merits of the matter. And the court doesn't have, with respect, a discretion to elevate a factor that should be considered in the second leg of a discretionary order test, which is, do you get the relief you're asking for, and elevate that and import it into the first leg of the test so as to not engage the first leg of the test at all, because that, with respect, would be a misapplication of the test from Cordian Trading and the cases that followed, Minister of Finance versus Oak Bay and others, which this court has approved of.
But is that not a bridge too far?
No, with due respect, it isn't, because what we also know, for example, in moot matters, where the court considers moot matters, in some instances, even though the relief may be moot, like if you consider the al-Bashir case, for example, after he left the territory of the Republic, any order that was granted by the court could not have been effected against him because he wouldn't have been able to be arrested. But notwithstanding that, the court pronounced upon the meaning of Section 4 of the Implementation Act, and it did so under the interests of justice. So even if, the point is, I suppose, even if delay is as bad as it is, and that's a factor that I can't run away from, it might be that it colors the remedy of the court, ultimately, but not as to the merits of the challenge.
So in other words, we have to deal with it to get to the report and find out whether the report is correct or not.
Yes. Whilst I'm dealing with that, Justice Matopo, I think in our earlier debate there were, and also I think perhaps with Justice Colopin, there was reference made to the tutor judgment.
It's me.
It is Justice Matopo. Justice Matopo.
Debate it with me?
Pardon?
You want to debate it?
I just want to give two references. I don't know that I necessarily want to debate it with you. The first one is that I would respectfully submit that you'll recall what I read out earlier about how the panel construed sufficient evidence and how it used prima facie and sufficient interchangeably. You recall I read that out for the record. It's that para 75 from page 90 of volume 1. And what we would submit is that conflation of the terminology, if we accept it's a conflation of the terminology, is not a conflation of the substance and the threshold that the panel satisfied itself with. Because what Justice Unterhalter says at paragraph 51 of Tutor is he illustrates where that kind of conflation would be an issue in respect of the ultimate outcome. He says the following, and I apologize, I'm reading from my phone. It says, perhaps in contemplation of this difficulty, Applicants' Counsel in oral submissions before us extended the remit of the applicant's appeal. Counsel submitted that the trial court had, in addition, failed to formulate the correct test for putative private defense and then applied the wrong test to the evidence. That, of course, is an error of law. It carries the risk of unsound conviction and unfair trial and does engage our jurisdiction. And what we would say is that's not the territory that the panel is in. Because in that paragraph 75, even though they subsequently used the phrase prima facie evidence, what they are at pains to say is that their understanding of prima facie evidence is the same as meeting the sufficient evidence threshold. That's the first reference, if I may. The second reference that I will give in respect of that is paragraph 153 of that judgment, which I understand comes from the minority judgment of Justice Colopin. And what that says...
What paragraph is that? 153?
153, yes, Justice Matopo. I think it's on internal page 49. What Justice Colopin says here is, first, and if I can find it, firstly, there simply cannot be any ambiguity. In the extempore judgment, the test is correctly formulated as subjective. There is the labeling of the test as being objective, which I have sought to demonstrate could have only been a patent error if indeed it was a term used by the judge. This, coupled with the recognition in the first judgment that the words objectively considered may have been benignly intended, must reduce the scope for ambiguity. Again, the phrase objectively considered cannot be viewed in isolation. And we would say that's the correct approach with respect to take here.
But you know that my brother Colopin was in the minority.
Oh, I'm not disagreeing. All I'm saying is that that's the exact facts that we find ourselves in here, because remember the majority judgment and para 53, or 51, which I just relied on, I say with the greatest of respect supports my contention and doesn't detract from it. So the way in which I read this judgment with respect is that it's supportive, both the majority and the minority is supportive of what the panel did.
Thank you, Mr. President.
Thank you, Justice Matopo.
Mr. Premier, just with regard to the principle of the separation of powers.
Yes, Justice Eagleman.
How far should this court go in telling Parliament how to do its work? Or can it?
It can. That's how constitutional supremacy works. But the point at which the line is drawn, with all due respect, must be determined on a fact-by-fact basis. If it's something that is patently unlawful, it would be a bit odd under our system of constitutional supremacy that a patently unlawful decision, however you define the unlawfulness in the hypothetical example I'm giving, could stand purely on the basis of separation. That becomes justiciable because of the unlawful consequence. In this particular case, the debate is a little bit narrower than that, because what we're saying is that it may be open to argument. It might not be patently unlawful, but what we're dealing with here is we're dealing with a situation where the ostensible reason given by the majority might, if the court drills down on it to interrogate the sufficiency of that reason and the consequences which flow from that decision, results in an unlawful outcome which the court must remedy. So I can't posit it in a hard and fast rule, but that's the way in which a basic structure of our state works in terms of constitutional supremacy, is that the court does actually have, under its enforcement of the constitutional powers, quite invasive powers against another organ of state. And what we're suggesting is we're not asking the court to eliminate Parliament entirely. We're asking the court to preserve Parliament's participation, but where it does so appropriately so as to counteract any potential abuse that arises from the majoritarian nature of our political system, which is what EFF2 tried to do. So that's as far as I can take it with respect, Justice Siegerman.
Thank you, Mr. Premier.
Chief Justice, there needs to be a little musical chairs so that our learned friend Mr. Katz can come forward.
I will wait for
Do we have your leave to rearrange?
Yes.
I'm indebted. Thank you, and thank you to the members of the court. Sorry, Anton.
Chief Justice, I think the chairs have been rearranged. I hope I'm not on the Titanic, in the sense that I intend in my half an hour to try to assist the court in understanding the African transformation movement's understanding of the debate that has just happened in the last 2.5 hours, and to explain why the ATM suggests the relief that I'm going to suggest at the end of my presentation. And now take the court to page 1, where there are a number of prayers that the EFF asked for. There are 8 substantive prayers, and we're going to submit that prayer 1 is the exclusive jurisdiction prayer, and that goes without saying should be granted if the court's of the mind that exclusive jurisdiction is present. We submit that prayer 2 should be granted on the basis of the evidence presented, as well as, importantly, the arguments presented by the President, the Speaker, and the ANC to this court. Because that's what I'm going to focus my address on. What are the arguments by the President, the ANC, and the Speaker? And we submit that the relief that is sought by the EFF and by the ATM should be granted on those arguments. Prayer 3 and prayer 4 we do not ask for. We do not think it's necessary if the court gives prayer 2. Prayer 5 is the substitution prayer. We do not submit a case as appropriate. This case is inappropriate for a substitution case. Prayer 6, we submit that 6.1 ought to be granted in perhaps a slightly different form to the way it's currently crafted, but I'll come back to that. Prayer 6.2 is not necessary. Prayer 7 may or may not be necessary, but it's probably not, but we'll come to that. So your court will understand that the ATM submits that 1, the rule is bad. And once that's the case, if we are right, that the rule doesn't give effect to EFF2, read with Section 89 of the Constitution, there are a number of consequences. The first consequence is that the applicants, that both the EFF and the ATM, are entitled to a declaratory order that the rule is unconstitutional as a matter of law. The second consequence is that when the National Assembly voted in terms of the rule to let's call it strike down the report or avoid the report, whatever words one might use, it then acted unlawfully because it was acting in terms of an unlawful rule. So that's the primary argument that we make. The rule is bad. We don't submit in the alternative that the resolution was bad, but we submit that the resolution was bad on the basis of that which the President and the ANC, not the Speaker, on that which the President and the ANC tell this court about how that vote took place. So the ANC, if I may just jump to their heads, they tell the court what is going on here. And they say in their heads of argument, the easiest place to find it in paragraphs 4 and 5, they explain in paragraph 4 the correct facts. And let me just start in